Hello there, Year 13s. So, as promised, I said I was going to do you a little video for any content that we hadn't managed to get through in class. So this is going to be the first one that I do for you, and it's going to be introducing Article 11. So Article 11 is the right to freedom of assembly and association. Now, assembly, or to assemble, just means a group of people gathering together in one place for a common purpose. So if you think about the Avengers Assemble movie, if you guys watch that, it's all to do with the Avengers coming together for whatever they come together for. I haven't actually watched it myself, but you get the gist of it. So assemble basically just means a group of people coming together for some reason or another. So if we look at section 1 of Article 11, it says that everyone has the right to freedom of assembly and the freedom of association with others, including the right to join a trade union for the protection of his interests. We'll have a little look at what trade union actually means a bit later on. Article 11 is a qualified right, so all of the rights that we have looked at, apart from Article 2, the right to life, is a qualified right. So that means that it can be taken away in certain situations. Now, the limitations of this for Article 11 are set out in Section 2, which we'll run through a bit later. And as with the other articles, the margin of appreciation will vary from case to case. So if I was in class right now, I'd be looking at Arij and asking her, what does margin of appreciation mean? And no doubt she would turn around and say to me something along the lines of, it means each country has some form of discretion. And the reason for that is because the morals varies from country to country. So what we find acceptable in this country might be different to what is acceptable in other European countries. Article 11 has a positive and negative obligation put upon the state. So the state has a duty to take positive measures to ensure the rights provided are secured for their citizens. And citizens have the right not to be prevented by the state to meet with others, except under any circumstances that are permitted under Article 11, Section 2. So if we break Section 1 down bit by bit and have a little bit of a more in-depth look, we'll start with freedom of peaceful assembly and what that actually means. So this applies to static meetings, marches, public processions and demonstrations. This right must be exercised peacefully without violence or the threat of violence in accordance to law. So if there is violence or a threat of violence, then people will automatically lose that right, okay? So the state can intervene and take away their right to freedom of assembly if there is violence or threat of violence. Article 11 tends to apply to gatherings that are political or economical in nature. However, it is unlikely to be applicable to gatherings that are purely sporting or social in nature. So, for example, a football match or people gathering in a festival might not be covered in this situation. And it could be the case that a totally peaceful assembly can still be disbanded by the state without violation of Article 11 taking place. And this was seen in the case of CIS versus France. Obviously, there is the margin of appreciation and things are judged on a case-by-case basis. So it really depends on the facts of the case. But in this particular one, it was found that an assembly can be totally peaceful and still be disbanded by the authorities without there being a violation of Article 11. Now, it can be that a demonstration may annoy or give offence to people, and that's totally fine. So this was shown in the case of Platform Arts for Das Liban versus Austria. And what we had here is we had a doctor who performed abortions. And then we had a group of religious people who decided to demonstrate in protest against this doctor. So they marched to his clinic. Now this caused a counter demonstration whereby there was a group of people that were meeting to then demonstrate against the religious group who were demonstrating against the doctor. And what happened was that the original group, the religious group, felt kind of fear of the opponents. They felt a bit threatened, and it was found that the state could interfere and break up the counter demonstrators because the original group had a right to demonstrate without there being a fear of their opponents, so to speak. So the point of this case here is that sometimes a demonstration may lead to a counter demonstration, but demonstrations must be able to be held without fear of their opponents. So sometimes the state must interfere in order for that to happen. It has been found in cases, namely G versus Federal Republic of Germany, that where assembly is designed to cause disorder, then it would not be held within Article 11. So if people have gathered or met purely to cause disorder, then they won't have their Article 11 protected. Also, where assembly takes place on private land, the owner of that land is only able to prohibit the assembly, providing this does not prevent lawful protest taking place in a suitable alternative place or by an alternative method. And this was shown in the case of Appleby versus UK, whereby there was a group of people that were demonstrating in a shopping centre, and it was found that they could only really demonstrate in that shopping centre because what they were protesting against, or what they were protesting about, was to do with that shopping centre. So there wasn't a suitable alternative place for them to do this demonstration. So that's it for freedom of peaceful assembly. Now, the second part of Section 1 is about the freedom of association with others, including the right to join a trade union for the protection of interest. So let's look at this one in a little bit more detail. This is the right to come together with others to form an association. This includes the right to form and join trade unions. Now, a trade union is an organisation with members who are usually workers or employees, and the whole purpose of them is to look after the interests at work, so employers' interests. So it could involve negotiating agreement with employers on their terms and conditions or on their pay, for example. Lots of people are parts of trade unions. I'm part of a trade union. Most teachers at this school will be part of a trade union. So if you have a look at the pictures there, we've got one trade union called NASUWT, so that is a teachers union, and basically if I was in a spot of bother at work for whatever reason, maybe they weren't treating me too well, I could call up my trade union and ask for a representative to come in and meet with the school, and basically they would be there to protect my interests and kind of defend me. So yeah, they're very, very useful. It's not just for the teaching profession, it's all different types of profession. So it could be nursing, for example, it could be to do with transport, so people working on the tubes, they'll belong to a certain trade union, and the whole purpose of them is that they are there to protect employees' interests against employers. So yes, you have the right under Article 11 to join a trade union, but equally you have the right not to belong to an association or a trade union, and this was stated in the case of Young, James and Webster versus the UK. Now, the meaning of association is not actually defined, but it was found that it's not just spending time in other people's company, as seen in the case of McFeely versus UK. So the meaning of association is quite broad because it is not defined. It has been found that political parties have been found to be an association, and this was found in the case of Redfern versus UK. So, for example, Labour, that's a political party, Conservatives, Green Party, there are lots and lots of different types of political parties, and they will have millions of members within within the country, and it has been found in Redfern versus the UK that a political party is an association under Article 11. So that's it for Article 11, Section 1. Pretty simple. Now we're going to have a look at Section 2. So if you remember, this sets out the limitations of this right. In other words, occasions where Article 11 can be taken away in justifiable circumstances. So Section 2 provides that no restrictions shall be placed on the exercise of these rights other than such that are prescribed by law and are necessary in a democratic society in the interests of national security or public security, for the prevention of crime and disorder, for the protection of health or morals, or for the protection of rights and freedoms of others. This article shall not prevent the imposition of lawful restrictions on the exercise of these rights by members of the armed forces or the police or of the administration of the state. So it is worth noting that the limitations that are set out in Article 11, Section 2 that we've just looked at must fulfil a criterion of proportionality. So this involves looking at the following questions. Is the limitation that's been imposed effective? Is it the least intrusive measure possible? Does it deprive the very essence of the right? And is it balanced between the competing interest as a whole? So what this is basically saying is that yes, there are occasions where Article 11 can justifiably be taken away. However, any measures taken must be done so in proportion, and in order to kind of balance out this proportionality issue, these are the questions that will be looked at by the court. So if we go back to what Section 2 says and take certain sections of it bit by bit, and we'll start off So prescribed by law, this simply means that there must be a clear, precise and predictable legal basis for the interference with Article 11. The next part, necessary in a democratic society. So there are several features of a democracy, things like citizens being able to vote, citizens being able to express themselves and voice their opinions, but also the right to assembly. That is a huge feature of a democratic society. Now, democracy is highly protected. So there really needs to be, as it says, a pressing social need for the interference. And in particular, the interference should be proportionate to the legitimate aims pursued. So I repeat that. Freedom of assembly is a feature of a democratic society, and democracy is massively protected. Therefore, in order for Article 11 to be taken away in a justifiable way, there must be a pressing social need for the interference, and the interference should be proportionate to the legitimate aims pursued. Okay, so when we are looking at the legitimate aim must fall under one of the following categories. One of the categories is in the interest of national security. That one's pretty straightforward, and it will include things like counter-terrorism measures. Another category is for the prevention of disorder or crime. Now, the majority of cases taken to the European Court of Human Rights are dismissed as the court takes the view that each state recognises the need to protect public safety. Another category is for the protection of health or morals. So we had a case called Lamela versus Finland, and it had an association called the Cannabis Association of Finland, and the whole purpose of that association was to influence intoxicant policy and the legalization with a view to making the personal use of cannabis legal for Finnish citizens. So they were a group who were kind of campaigning for the personal use of cannabis to be legal. The Finnish Minister of Justice refused to register the association with the aim of protecting health and morals of the country, and that was found to be fine. Okay, so there was no breach of Article 11 because it was found that the state were protecting the health and morals of the Finnish citizens by refusing to register this group. And then the final category is for the protection of the rights and freedom of others. And again, that's very straightforward, and there's no notable case law for